How do you get your own independent blood test from a hospital of your choice?
Now, in many states, they may not let you have that much latitude. So if they say, well, the only place you can get a blood test is we're going to have an EMT come get it from you at a jail cell or something, that's fine as long as you can have your own independent test done at a laboratory that you know is not part of the government, because again, you want it to be independent. So in many states, like Georgia, you can go for blood. You're not going to get a number that night because it has to be sent off for analysis. And you want a whole blood test. You don't want a plasma blood. You want whole blood because that's what's being tested by the GBI or the investigation of the police. Once you've taken a blood test, if you say in Georgia, I'd like to now get a breath test from a different police station, they have to take you for a breath test too. And after that, if you say, I'd like to get a urine test, they have to take you for that too. Because in Georgia, they can ask you for all three, so you get a right of independent test to all three. But most states aren't that liberal. They say you get one shot at it, and that usually is a blood test in most states. So that's why I'm telling on this tape that you should ask for blood, because it's a more precise test. It's your evidence that you could use to refute whatever numbers are on the breath machine.
I don't really trust breath testing. Can't I insist on a blood test and not even submit to the implied consent breath test offered to me by the police officer? That's how it worked in California.
Well, you're talking about your independent blood test is what you're asking for, because when the officer asks you to take a type of test, you don't get the option. If you don't take their type of test, if they ask you for breath, in very few states, California being one of the exceptions, you can say, I want a blood test instead of breath because I want to be able to have my own analysis of that later. Most states like Georgia, if they say, I want you to take breath, and you say, I'd rather have blood, that's a refusal in Georgia. So you need to follow what the police say. Every state's a little different. That makes my job very hard when I'm trying to discuss this with you, discuss this subject with you on every other state. But by getting the independent blood test, you have the most reliable type of test and something that can be tested again. Because recently I had a case that the state said my client was an 09 and a little over an 09. First test I had was under an 05, second test was a .021. I did 2 separate lab tests, so that person was charged with per se being over the legal limit when she was not.
Well, the test result from the police station of .09, was that breath?
No, that was a blood test.
Oh, you had the blood retested.
Retested it.
And there was
2
that
separate
much
labs.
difference?
Yes, that much difference.
Which tests in a DUI case are scientific and which are not scientific?
Well, the science is based upon breath and blood testing primarily, but field sobriety evaluations have been used now for more than 30 years. Field sobriety evaluations are things like walk and turn, follow a pen with your eyes, stand on one leg, sometimes partial alphabet. Those evaluations are not scientific and they're all voluntary, but most people don't know that when you stand out of the car and the officer says, I want you to do this for me so I can make sure you're safe to drive, you have no obligation to do that. The only thing you have an obligation to take to keep your license is what happens after you're arrested. Once the cuffs go on and they ask you to take a test by reading you some type of advisement, if you don't take the test then you could lose your entire right to drive.
How long does it take for alcohol to leave my body once I've consumed it?
We all burn alcohol out of our system. It's called metabolism. And every hour, the average person will get rid of a .015 per hour. So at your body weight of about 130 pounds, let's say you drank enough to be a .12. Let's say that you had enough drinks, which would be about 4.5 light beers for you. If you drank that, and that was a 3-hour window, and then you're tested 3 hours after the first drink, you get to take off 0.015 times 3, or is 0.045. So your alcohol level that would have been the high of 0.12 would now be a 0.075, which is under the limit. The burn off continues to happen on a steady rate all the way until the alcohol is out of your system at a 0.015 per hour. That's a very slow burn off, but again, it does burn off. Otherwise, you'd drink today and you'd be drunk a week from now. Your alcohol level can be rising. Usually if you've had food, that can go up to 2 hours. It keeps rising up to a 2-hour peak. If you have no food in your system, the alcohol goes almost straight up. If you don't have any food in your system, it goes straight up. And that peak can be much higher than if you had food that helped to slow down the motility or the burn off, or the food in your stomach slows the alcohol from getting into your bloodstream. So if you have nothing in your system, it goes in like an injection. But at about 30 minutes after that pitcher you downed, you're going to be at peak alcohol. Now, let's just say the pitcher was a 40-ounce pitcher. You're going to be over the legal limit at your peak, and that may be when they're testing you 30 minutes out. But again, it reaches its peak and then it starts eliminating very slowly at a 0.015 per hour. That takes forever to come out of your system, like 6 or 7 hours to be completely out. So depending on when they get the tests, that's what the number is. But in many states, the rule is that the police don't have to relate it back to the time of driving. If they get a test within 2, 3, or 4 hours, that number is considered to be your alcohol level regardless of whether or not it was the actual level at the time of driving. They get to use that against you because that's what the statute says, that is your number if the test was taken within the statutory time period. In Georgia, that's 3 hours. You could have been rising or falling, but if the number comes out from a test taken within 3 hours, it's presumed that that's your number.
Can you still dispute that number? Or once the presumption that if you were tested within 3 hours of driving and tested at or above the legal limit, does that trump any argument?
Actually, in many states like Georgia, it's been statutorily prohibited that you can challenge it based upon that number being a rising or falling number. On the less safe charge or the impaired charge, if they're trying to use it there, you can argue it, but you can't argue it on the per se charge because it's been statutorily by our legislature says you can't do that. Other states like Texas and Florida, you get to challenge it that way, and they win many cases based upon a rising alcohol issue.
Defending a DUI case seems to involve many scientific issues and technical defenses. Is that right?
Absolutely, and the problem with it is most people don't work in this area all the time. They don't study this. They don't go to courses and take breath courses and field sobriety test courses. They just don't do it. They don't prepare. And I don't know how you can fight these cases. You can plead people guilty real well, but you can't fight these cases unless you know as much or more than the police and the people you're working against from the crime lab.
After I get my independent test and am put into a jail cell, what is the next step?
Some places release you after that point. Most people put you in jail. One reason some places aren't doing it anymore is it's very expensive and also a little bit risky because most people charged with DUI are not high risk, and you don't want to put them in with a population that may be high risk. But if you are in custody, you should just focus on getting out. Don't be having conversations saying, man, I shouldn't have been to the strip club, I shouldn't have had 20 drinks, whatever. Don't say that because that person may become a witness against you. These people in jail want to get out any way they can. If you get a sandwich offered to you and you don't want it, they'll be fighting over your sandwich. Don't talk to people in jail because they can be witnesses against you. Again, remain silent. That's what we have the right to do. We just don't have the ability. Anything that is given to the police that the police think is favorable to them to help them with a case, because you could come in with a lawyer fighting the case and say, I didn't have anything to drink, and yet you told the person in jail, well, I told the cop I didn't have anything to drink, but I had 5 Long Island iced teas. There you go. So that person can say, well, he admitted it to me even if he didn't tell the cop.
If I am in police custody and being driven to jail, my inclination would be to try to talk my way out of the situation. Is this a bad idea?
It's amazing. Some of the smartest people think they can talk their way out of a DUI. That might have happened 35, 40 years ago. That doesn't happen anymore. The cops want you to talk. They want you to talk as much as you want to talk. They'll let you talk in the back seat and they keep the microphone on all the way to jail so that you'll say something stupid on the way. It's an amazing thing. People think they can talk their way out of it, and they really can't anymore. The officers have, again, some of them have quotas, but all of them who are DUI task force officers only took the job so they could clean up the highways from anybody drinking and driving. And I do mean drinking and driving. They don't want you out there even if you're not over the limit. So the point of it is you have to understand what the game is, and once you understand what the game is, you simply don't give the other team all of your playbook. You remain silent, you do the things I'm saying, and your case is so much better that you have a great chance of winning, whereas if you do everything wrong, you have a very poor chance of winning.
Mr. Head, you called the prosecution the other team. When you handle cases for clients, do you treat the police officers like players on the opposing team?
Oh, sure. I have many officers that are great friends. I have their cell numbers. I consider them friends, and I know they're well-trained officers. So we get along well because they know I'm doing my job and they're doing their job. It's nothing to do with that. I've even called in 911 calls and had people arrested for DUI when I saw very bad driving. So I'm out there on the roads. I want the roads safe. But I'm saying for people who want to protect his or her constitutional rights, I'm telling you how to do it. There's nothing wrong with that. It's not like I'm telling you some secret formula. I'm telling you what the Constitution is there to do to protect you, but you give it up when you waive it. If you waive it and say, I'm going to answer your questions, I'm going to dance around and do the field test, then you're stuck with your own behavior because you gave up your constitutional rights.
Yet it sounds like most of us are not even aware that we are waiving our constitutional rights when we comply with a police officer's requests.
No, they think they're just going to talk their way out of it or drop a name saying, well, you know, I know the chief of police, or, well, you know, I won the Super Bowl this year. Whatever they might want to say, that's never going to work because the officer is just going to come back with the fact, well, it doesn't matter to me if you won the Super Bowl. My job is to make the road safe, and I don't think you're safe. So that's all you're doing is giving an opportunity for them to make a much better case against you by opening your mouth, because there's nothing good to come from that.
Part 3, After Jail and Your Defense. Once I am released from jail, what can I do to help my case and improve my defense? So I'm out of jail, I've successfully bonded out, I'm finally home. What do I now need to do, if anything, to protect my rights?
Well, most people need sleep, but the most important thing is while it's still fresh in your mind, write down chronologically every word, everything, every incident that was said all the way through. You'll remember it better that day than any other day. Once you get that down, the next thing to do is to contact an attorney that's a specialist in this field. You don't want to find somebody who just dabbles in this. You want to find somebody who has the credentials that this is his or her specialty. Then what you want to do is make sure you protect your license, because in every state, if you've refused, that can cost you your right to drive, or if you've taken the test and you're over the legal limit. For adults, 0.08. For anyone that's under 21, it's either a 0, a 0.1, or a 0.2, depending on the state. But if they say you're over the limit, they're going to give you an administrative suspension. And that administrative suspension or revocation in some states can take away your right to drive even before you get to the criminal case and try to fight it in court. So you need to file an appeal. Usually it's in a letter form, but you file a challenge to that administrative suspension, because that hearing can help you win your case later in the criminal case.
What is an administrative license suspension or revocation, and how does that relate to my criminal prosecution for DUI?
Administrative hearing goes to a different office from the criminal court in most states, not all states. But the administrative suspension is for you either being over the legal limit because you took the test, or for you having refused the test. And they try to go in and suspend you, and they'll give you a hearing with a different judge, an administrative judge, and that's when you can bring in a court reporter and get everybody under oath, and you can get evidence that can help you win the criminal case later. If you lose that administrative suspension, it only means whether you can drive or not, typically. But it doesn't have anything to do with criminal punishment, criminal record. So it's important that you fight that and contest that hearing, so you'll get a pretrial contested issue in front of another judge, and you can record that and use it for impeachment later if you get to the criminal case.
Can you tell me some compelling reasons for a prospective DUI client to contact you immediately?
In many cases, you could lose valuable evidence by waiting to talk to an attorney. For example, if you pulled into a service station that has security cameras, you might find great evidence there that the officer doesn't even have video. You can gather that information by getting a copy of that digital recording from a service station or wherever the camera might have been. You can then refute things that the officer says in his or her report. It's very valuable if you go out and gather that information quickly. If you wait around, you may lose that information, particularly if there's an accident with skid marks and physical evidence on the roadway. You wait a month, that's all gone. You'll never be able to recreate what happened.
What exactly is an administrative hearing? Where does it take place?
Well, if you bond out, you don't have a preliminary hearing. You bond out, you're going to have an arraignment, which is once the formal charges are being brought against you, you'll be asked to come to court and either admit your guilt or say not guilty, and it will be bound over. You have a right to have those charges read to you if you want them to be. Most people waive the reading of the charges because they can read, and then the case is bound over for a later hearing where you get a chance to do pretrial motions and challenge the state's evidence. For example, if you want to knock out the field test or if you want to knock out the breath test on some legal issue, you do it pretrial typically. When you retain an attorney to fight a DUI case, that attorney is going to file numerous written motions, and there might be some verbal motions made at trial or pretrial motions. But what you have to understand about those motions is that these are like hurdles that the prosecutor has to get over before he or she is going to be able to prosecute your case. A good DUI attorney puts many hurdles in front of the prosecutor to see if he or she is going to be able to jump those hurdles and get to the point where you can be taken to trial. So if you have the right attorney, you should expect a good bit of this to be done in the case, and you may have to attend a pretrial hearing relating to those motions.
Mr. Head, you make it sound like getting an attorney as soon as possible is of the utmost urgency. Is that true?
I'd say that's very true. Just think of it as if you were determined to have cancer. Are you going to wait around, or are you going to try to take care of it right away? So you need that person to start early, start treating it early. The same thing with a DUI. We usually have our investigator go out and gather the paperwork. Sometimes in as little as 3 days we have the video. It just depends on the jurisdiction. We want to see that while it's still fresh on the client's mind. You may even have witnesses that can be valuable, but they don't need to wait 2 or 3 months to interview them. We try to get this thing started because the quicker you get the information, the more details you'll get.
Even if you are told that your first court date is 4 to 6 weeks out, you need to begin investigating that case right away.
Absolutely. You'll forget, your witnesses will forget so many details, and even 2 or 3 days. You wait 3 or 4 weeks, they're not going to remember anything except just general information, and you'll get answers like, well, I think he next did this, or he might have done it this way. Well, those types of answers are useless if you're in a court of law. The jury wants to hear, the next thing he did was X, and then he did Y. I couldn't believe he did that. You need that while it's still hot. If you wait, people's memories fade, and they don't even understand the importance of it, so they don't write it down right after the incident unless you get to an attorney who says, let's get that information now.
Has it been your experience that celebrities generally get in contact with you quicker than your typical DUI clients?
And you know, the funny thing you asked earlier about athletes and celebrities, when they have a lawyer agent, like I've had in many cases, they know the importance. They will get us on the phone sometimes the very night of the incident. And sometimes it's not the athlete or the celebrity, it's their spouse that we're getting the case. But we get those calls because they'll track you down. Once we get those calls, we can move everything more quickly, and we sometimes are able to win cases for them because they did all the things that we ask everybody to do. They get to us quickly, and we can get that case put together, and sometimes solve those cases in record time because everybody's on top of the game when we start.
What is typically the most damaging evidence against your clients?
The worst evidence is what my client says and does that they don't have to do. That is always our worst evidence. If our clients don't incriminate themselves, don't do things that are voluntary that they don't have to do, we can beat the breath test, we can beat blood tests. I just beat a blood test with a .222, which is a pretty high reading not even 2 weeks ago. So the blood and breath tests don't bother us. Plus, if the person doesn't look like a .222, then you can actually show that that might not even be that person's blood. It might just be an error of some type because you can't look good at a .222. You're going to look pretty sloppy if you're really that drunk.
Mr. Head, all of us went to school and learned about our constitutional rights. Why do you think so many DUI suspects give up their rights and waive their constitutional protections?
I don't think people pay attention except to pass tests because they think when they see Dirty Harry that that's some murderer that's exercising his Miranda rights or following Miranda. That's not true at all. You have to know your rights when you're pulled over. Otherwise, you will inadvertently give up evidence that could convict you. And it doesn't matter what the offense is. If you're out there speeding and the officer's got a recording going and you say, do you know how fast you're going? And you say 87 miles an hour, well, that's going to be used against you. If you simply say, don't know, shake your head, don't even comment, then again, whatever the officer has as evidence is what's going to be used against you, at least not your own words, not your own admissions. And most of the time, the officer will say, well, where are you coming from tonight? Well, if you're coming from some strip club that's notorious in the community, that'll be the first piece of evidence offered in trial against you. He just came from a strip club. So why tell them where you're coming from when you're not obligated? Just remain silent. Where are you going to tonight? How far do you live from here? I've actually had officers that had the routine question of saying, how far is it from here to your home? Right after they've already gotten you to admit everything they wanted to. And then when you say, oh, it's only about a mile, officer, only about 2 miles. Then they say, well, how much would it have cost you to get a cab tonight versus you coming out here driving drunk and me having to arrest you? Now, that's a lot of nasty evidence to try to keep out in front of a jury. But again, that's the kind of things I see happening, but they only ask that after they already have everything they want on the video, and then they ask that just to seal the deal.
If you give them nothing, they cannot seal the deal.
If you just shut up, don't talk, remain silent. If you say anything, say, may I call an attorney now? I have the attorney's number. May I call the attorney? Most people on a jury are not going to understand why you're not allowed to do that, even though you're not. You're not going to be in the middle of an investigation allowed to pick up the cell phone and call. If you don't know your rights when the police officer confronts you, and if you don't exercise them and stick with it, you're probably going to incriminate yourself, and your own words, your own conduct, your own efforts to do field tests will be what convicts you in the majority of the cases that we lose. Is from what our clients do and say. The graphic that I'm showing you now is what I call my levels of proof graphic. I use this in most of my trials when I'm trying to show a jury just how hard it is for the prosecutor to prove guilt beyond a reasonable doubt. If you look at this chart starting with no evidence at the bottom and you go up the stair steps and move toward proof beyond a reasonable doubt, when you get to preponderance of evidence, that's 50-50 basically. When you go to clear and convincing evidence, which is the hurdle below proof beyond a reasonable doubt, clear and convincing evidence is the amount of proof a judge needs to take your children away from you forever, saying you're a bad parent. Above that, a higher standard is proof beyond a reasonable doubt. That's what we tell jurors when we're in a trial so that they understand they have to have overwhelming proof to convict you of a DUI. That's the type of thing that a DUI attorney should be doing in your trial.
What if it's 2:30 in the morning and the officer says, sure, call your attorney? What attorney is going to pick up the phone at 2:30 in the morning?
We answer it 24/7 at our office. If somebody's in the business of doing DUI defense, they'll be answering the phone 24/7. We answer it Christmas Day, New Year's Day, Hanukkah, I don't care when it is. We answer the phone because nobody wants to get a recording and say, call us on Monday, take an aspirin until Monday and call us back on Monday. We know that people who are in trouble want to talk to us now.
Perhaps one interesting part I found was that you have a nickname, and you're actually known as Bubba. Is that true?
That's right.
And how'd you get that name?
Very good question, and if I was in New York, I wouldn't use my nickname, but an older sister gave me that name and insisted that everybody call me that, and when I was an athlete, it was a great name. Bubba Head hits a home run. It stuck, and even though many people have told me to drop it, it is literally a brand. If you're in Georgia and you ask any attorney in the whole state, do you know Bubba Head? If they don't know me, then they came out from under a rock. They know who I am.
Well, now how do the judges refer to you?
Bubba, most of them do. Quite a few, and prosecutors too, and I even introduce myself to the jurors as Bubba if I'm in the South. If I do a case up in Michigan, I don't. In fact, the judge in Michigan with Patrick Barone had me in court. The judge didn't know I was there. Patrick said the new judge, we went from one court to another after we couldn't get the case dismissed at a motion, and the judge said, he announced, he comes to Patrick's case, and I'm sitting there, and he doesn't know, and he says, "Mr. Barone, what's this about you got some lawyer from Alabama named Bubba that's coming in to do this case?" And I stood up and said, "No, Judge, that's my cousin Vinny. I'm Bubba from Georgia." That's absolutely true. And then the judge took me up to the bench, said, come on up, Mr. Ed, I didn't know you were here." And so he comes up and he tells me his parents were from Arkansas, he likes Southern people, and goes through all this after he was just chastising Mr. Barone for bringing me in as co-counsel.
Mr. Head, you've discussed handling cases outside of your home state of Georgia. How is it that you are able to handle cases nationwide?
Well, when I go to other states, I have a local attorney as my co-counsel. I have to then be approved by the judge, sometimes through the Supreme Court has to approve me. And you also have to sign tax statements that you will pay taxes in that state. Everybody's after taxes. But I've done cases in several states. I'd rather go close to Georgia, but sometimes it's California, Michigan, places like that. But if the person needs my help and I think I can make a difference, I will take cases out of state. It's very inconvenient because flying is very difficult, but I handle cases and quite enjoy getting out of state because they don't know what I'm going to do when I get there. They just think it's some guy from Georgia coming in versus somebody who's there to beat them. No matter what else happens, I'm going to beat them.
Some guy named Bubba from Georgia.
That helps when they find that out. They usually are more relaxed. They think, well, what am I worried about? The guy's name is Bubba. And that's fine with me. Let them have their guard down. That's fine.
Have you ever had a judge in a particular courtroom across the United States not accept you as a co-counsel?
Never.
So that has never happened? No,
I actually had a judge that I thought was going to challenge me about what I knew about DUI law, but he asked the prosecutor first, like he was getting ready to let him object. He says, "Well, what do you think about this attorney from Georgia coming in? What do you think? Is he able to handle?" This was the first Michigan judge. And the prosecutor says, "Well, I've looked at his credentials and I can't imagine that this simple case he couldn't handle. He could handle any case, but this one's fine." Once the prosecutor said that, what's the judge going to do? Become an advocate? So the judge says, "Well, if you're happy with it, I'm fine with it." And that's how long the hearing lasted. But then I got to the next judge who was raising all kind of cane about some lawyer from Georgia because it was a felony case there. It was a multiple offender case. And the judge didn't want to be going into trial because he couldn't imagine who was going to try to fight a case in trial. But I just went on up to Michigan because I didn't want to have any questions and I didn't want the client to not have me as his attorney since he'd paid me.
In going to other states, in addition to learning new laws and procedures, don't you also have to know about that state's breath machine?
Well, that's a very good question, and the laws are different in every state. For example, in Michigan, when I knew I had that case, I had not been trained on their breath machine, so I went all the way to Ohio and took the factory course so I'd be prepared for that case. And I was kind of waiting for the judge to say, "What do you know about the data master?" And I was going to be able to show him my certificate that I'd taken the course. But again, whenever you take on a case, you better know all the science because otherwise you're going to lose. And in California, I've handled cases against Intoxilyzer, Intoximeter, and never had a data master there, but Draeger, and there's 4 major manufacturers. So you better know all the machines if you're going to fight cases nationally.
So there are different breath testing machines with different manufacturers in different states?
That's correct. The Intoximeter, the Intoxilyzer, Datamaster, and Draeger. Draeger's a German company, but they have national headquarters here too. So you better know how each machine works, and they all work on a slightly different method with different parameters, so you have to know how each of those machines functions.
What about the passive alcohol detector device, the one the officer attempts to use at the scene? Is that different between the states as well?
There are different manufacturers for what's called passive alcohol sensors, and those are just to determine if alcohol is present. By the way, they're making new technology for cars that you can't crank a car if the passive detector realizes there's alcohol in the car. So pretty soon your car may have one of these. But these go back for a while. Mind if I show you something in one of my books here?
Please do.
This book was written in 1991, and the PAS was already out then and being used in several states. And this is one from a South Carolina location, and it's easy to spot because I think I have pretty much a whole page. It's a device that looks like a flashlight, and they'll stick this in the window, and it has a little sensor that then tells the officer that this is alcohol in the car. What you're smelling is alcohol versus some other fruity smell. So these are the kind of devices, by not rolling down the window, they can't just stick it in there. So this is the very first book I wrote in '91, and it's also the largest selling book on DUI ever, a little over 10,000 copies sold.
101 ways to avoid a drunk driving conviction. Well, we've covered many of them today, but 101 ways, that's quite a few.
Well, I'm revising that book now, and this year I'm publishing the 2013 version, which is 202 ways to avoid a drunk driving conviction. Let me cover 6 mistakes that can make your DUI case worse. With many celebrity clients, I find that social media messages give the prosecutor a roadmap to find where my client went that night, what they did, and pick up videotape from every venue that they attended. Also, by twittering bar and club locations, the prosecutor can go there, find witnesses, and also find additional videotape from wherever they've been. If you're driving a fancy vehicle that draws police officers' attention, that can be the basis for a stop. If you want to be safe, get in a minivan. Police officers rarely pull over a minivan. One of the most difficult problems for high-profile clients is when they are expected to answer media or TV questions and they're not prepared to do so. Let your attorney handle those questions and refer all matters to your attorney rather than try to discuss them in public. One of the other problems we sometimes have with celebrity clients due to their busy schedules is not following the attorney's directions for being prepared for the court case. You have certain things that you need to do to be prepared, and we ask you to do those in sequence so that we can be prepared for you. One other place that we sometimes have problems due to schedules for celebrities or pro athletes is that we don't have access to the client when they're away at practice or spring training. So these problems can occur, and we need to be able to communicate with you on a regular basis. Severe financial penalties of up to $250,000 per violation can occur, and possible federal criminal prosecution where federally protected property such as this is copied or reproduced. In addition, I have 3 practical reasons for you not to reproduce this or make it public. This is important because, number 1, as in your business with TV shows, movies, sports events, concerts, private internet content, blogs, DVD rights, whatever you may have, this is my intellectual property that I'm donating to you for a good reason. That's to have a positive impact on celebrities and sports figures' lives and careers without the completely avoidable conduct that is often a result of bad decision making by people who lack good information about the risks they face. I have plenty of legal business in Georgia without having to read about this, hear about this, or watch it in the evening news with another report of a high-profile sports or entertainment figure being publicized and giving that person a bad reputation by virtue of the criminal charges. Second, I intend to offer this information in a significantly revised format as a money-making video production. Sales of this video will help me recoup the cost I incurred in making this. Just like my books on DUI laws, this video is created to generate a return for my time, my knowledge, my effort, and extensive production and distribution costs. Therefore, my federal copyright protection must be zealously guarded so that my property is not copied, expropriated, or given away for free. Similar to what you do to make money, much of which is protected by similar copyright-protected works, you clearly understand that. Third, even though you would not think this could happen, during jury selection for my client's trials, an unscrupulous prosecutor who is trying to sway the opinion of potential jurors against me and my client will sometimes ask questions of jurors such as, have you read any of Mr. Head's books on how to beat a DUI case? Or have you attended any of his DUI seminars? Or have you seen his video that he produced to help celebrities and athletes circumvent the law? Some prosecutors may make it seem that I did this for rich folks who were stopped for a DUI charge, but not for the general public. So, not keeping this video private can and will harm me for all those reasons, and therefore cannot be shared or duplicated by you. Any agent or athlete can obtain a private password from my office to enable him or her to view this video by contacting me at this email address, wchead@sos.pro. I've launched this special private website and will provide you and your agents with a special password so that you can access sos.pro for more information on DUI, DWI laws if you want more information. You can use your password to watch this video several times if you wish to do so. Nothing in this video is designed to advise you about how to circumvent the law or help you avoid being held accountable under the laws of your state. This video is designed to give you a crash course in the American legal system, your constitutional rights, and to explain how police officers are trained on how to have you incriminate yourself. At this point, we're at the end of the video. You can tell that because I have on a different tie, a pink tie. I'll tell you more about the pink tie in a moment. But if you or a family member or a friend has a problem and it involves criminal law, be sure to give me a call if I can help you, because even if I can't be there, I probably can refer you to an attorney in your state or your jurisdiction that knows the law and can help you in the case. I also have on the pink tie for another reason. Some people have asked, how do you send out a free video for such a lengthy production? And the bottom line to it is, I didn't want anyone to not watch this because it cost them a penny. I want everybody to watch it so that you don't get in trouble. However, if this video has been valuable to you and you feel that you want to send something, I have 4 charities listed below. If you pick one and send a donation to this charity, I would be greatly appreciative.